Hello, my darlings. Welcome and happy hump day. So, where do I start? I was a little behind because there's been, I don't know, health issues in my family. And I wrote this episode last night or yesterday, was going to do it last night, but if I'd have come on last night, I think I just would have sobbed into my microphone. We don't need to do that. But hey guys. Yeah, I'm upset. I'm upset about so many things. So it's probably good I wasn't live last night, give myself time to calm down. Just just because I you know what? And I love you guys because you are so much like me. You want to see justice. You want it to be served in every way it possibly can. And hey, Carol, and hey, Mishan. But even like when it came to being subpoenaed, I've said it so many times that if it had just been me, I probably would have just shriveled up and blown away. But it wasn't just me. I saw people Jungle Feb Joe. Thank you. Um, because it was people that I care about and I saw them crying and I heard them crying and knew what they were going through, it gave me all of the power that I needed to fight that. And to fight it hard and to fight it strong because I wasn't just looking out for myself. I I wanted to stop that subpoena. At the time we were the first of us that got subpoenaed. At the time that we were subpoenaed, there was like 42 of us. And it that subpoena in the process of me, "Hey, Ricardo, haven't seen you for a bit. Good to see you. Hi, Miss Cass and Lovely's gotta catch up later. You got some exciting you always got something going every evening." But, um, while while I was preparing my response to my Google subpoena, more people got subpoenaed on X, and I realized and TikTok, and I realized, "Okay, this is not done yet. This is gonna go on." And it's the same subpoena, and it was being used in different on different platforms, in different not just different states, but different countries, and I thought, "I gotta if we can fight this, if we can get the judge to rule on it and say this subpoena's no good, it can stop it from being used on more people, from making more victims." And maybe it's just those of us here, this can we ask for the manager? Exactly. Those of us here in this community that are like this, but that's what I wanted to do. I didn't just wanna take care of myself, I wanted to help everybody. And I wrote mine, then, Leanne came together and we bounced ideas off of each other. We each adopted I some of like, I took some of hers, she took some of mine. We brainstormed it, and then I offered my motion to quash to anyone who wanted to use it, and several people took me up on that, and they used it, and I loved that it was able to help everybody else. That's just the way not just me, all of you guys who come here, that's the way we operate, that's the way we think. We want it to do the most that it can do to help everybody. So as you guys know from way back, before I knew much about the parties to this case, one of my main things that I talked about was about the New York Times article because I felt like this is just wrong. This shouldn't be happening to people. And I zoned in on the subpoena that Blake claimed that she had. And I knew that you cannot have a subpoena without a lawsuit. But where was the lawsuit? So I knew that something was wrong with that subpoena. So long before we had a name, we knew the name Van Zandt. Long before that, some of my first videos on this case specifically were about that. Like in my first 5 videos, there was a lot about that. And so and it really bothered me. I'm like, "Well, how was this used?" And then the more we learned about it, I'm like, the first thing that I said when I first talked about Van Zandt Van Sham was that this is so dangerous because there were attorneys out there saying, "Oh, this is clever," or "This is a loophole. Oh, there's nothing wrong with this." Attorneys in New York can write their own subpoenas. And I was saying, no, 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 something's wrong here. And and like I said that, a lot of you said that, and those of you who were around then, and the the legal community was all saying, uh, yeah, attorneys can write their own subpoenas. Who was right? We were right. We were right. That was not okay. That was a sham lawsuit. And so what I said is this is so dangerous because if it is not properly handled, if it is not ruled on, if it is not expressly forbidden and said from a court of law, you cannot do this, that people were going to go on and do it. And I firmly believe that Van Zandt is not the first time that this was ever done. You're not late, J Tor. We just started. Um, that this is not the first time that this was done. And that if it doesn't get ruled on, if it doesn't get firmly stopped, it's going to continue to be used. And what did I say? I said women will be the main victims. I don't know. Those of you who were around at that time, you will remember that. And so I wanted a ruling on Van Zandt for that, not just for the Wayfarer group. I don't think like that. You still have my Costco pick and bulk subpoenas. I don't think like that. I've said so many times, every ruling that a court, especially a federal court, makes is not just about that case. It doesn't just affect that case. It becomes part of the record, and other future judges may use those rulings to make their own decisions. That's one of the first things that I said, because to me, it's never just about what this decision affects right now. This is about everything else that can come later and how it will affect. And that's why I really wanted to see Van Zandt dealt with correctly. A ruling on it to stop it. I wanted our subpoenas. I wanted a ruling on it to stop it. And this court allowed Ezra to just slither in. The court's response to my subpoena was due on Monday, and Ezra slithered in on Saturday and withdrew it. And he allowed her to do that. And by allowing her to do that, that meant he didn't have to rule on it. And that meant that Blake could keep using it, and keep using it she did, and went from 42 at the time I was subpoenaed to 107. That's what I didn't want to see happen. Okay, not just that, but I also wanted to see, what did I want to see? So Van Sham, the subpoena. Oh, and 47.1. I really, really wanted a fair and just ruling because, as many of us have said all along, that we felt it was unconstitutional, not First Amendment unconstitutional. I don't know why that was the only thing addressed, but there are other amendments to the Constitution, including people have a right to defend themselves in court. And I felt like the way it was introduced to this court is it took that right away from people. And that's why I felt it was unconstitutional. I wasn't the only one. Other attorneys said it was unconstitutional. And so I really, really wanted to see 47.1 fought hard and ruled unfairly, and that it would be fully investigated instead of just taking Ezra's warped interpretation of what that law was, that it would be investigated. Okay, what was this law for? And is it being presented properly in this court? And then have it be ruled on according to how it was supposed to be ruled on. So not only do we have a long history of that bill becoming a law, and I did that video a long time ago. I went through and I found the videos of that bill as it passed through the assemblies and the Senate, and I shared it to show you what they said about that bill. And not to take Ezra's word for it, because Ezra was twisting it into an unrecognizable law. And now we don't just have that. We have the lady who wrote the law who has come out and said, this is not what this law is for. There are guardrails for the people that are accused. It's not meant to take away their right to defend themselves. And she said on multiple platforms, in multiple interviews, she said, Blake should not be eligible for my law. And she said, Ezra is out there rewriting my law. She's twisting my law. She's turning my law into something that I didn't want. Taking authorship, just like Blake and Ryan. And still, even her words were ignored. And this weird one little sentence from one bullet point in a questionnaire is how that was interpreted. Not anything, not any official document about the making of this law. Not that. But one bullet point from a questionnaire from before the many amendments of this bill, before it became a law. Only that. That point was never ever mentioned again until Ezra took it and twisted it. And all of the amici, the people who wrote those amicus briefs, they took it and twisted it. And that's what the court ruled on, their interpretation. That is not what's been put out there by the California legislature. But anyway, I've gotten on a tangent again. But that's the point to me. And because someone had said that they're burning up and they're disappointed, and I am too, because the settlement, and I'm not even prepared to go through that because I'm upset about it. But as you guys know, you've probably all seen that the settlement in full has now come out. It's been released, and I put I think I put it here too, not just on X. I haven't been home much lately, but the settlement was released on Megyn Kelly, and I know she's controversial, and so I hate to bring up people that are controversial because then it kind of distracts from the message. So if you don't like her, that's fine. But that was the only place that I could find that had the settlement. And no, Donnie, I didn't see. So Donnie says Victoria Burke was on Billy Bush again today. She said after she was on Megyn Kelly, her phone blew up and she hasn't had time to get back to them and won't be. Ezra is calling. Wow. Yeah, she should just give her the cold shoulder and do what she can. Oh, it's on your website too. Good, Carol. Yeah, give Ezra the cold shoulder and just come and speak in New York about what your law was meant to do and fight it. But Ezra is calling, change your number. It's on my website too. Okay, so for those who don't watch Megyn, and I don't follow her, I did watch this episode. I've watched a couple of hers that where she did have specific people interviewed, like Brian Friedman, and that was the only place you could see that information. But for those of you who and I understand that I've told you guys a million times, when I don't like someone, I'm petty and I won't give them a view. So if you don't want to watch, I completely understand. So you can go to Carol at docketupdates.com. She has the most magnificent website. If you're not familiar with it, she has gone through and documented so much about this case and organized it so beautifully. I've used it so many times. And she is currently making a timeline, and I'm sure it's going to be absolutely amazing. And I did put a post up yesterday that I watched her live with DFJ, and Carol was talking about that it seems like two of Ryan's text messages were never unsealed. And it's very, very shady that they weren't. And it was such a big unsealing, and so much was happening that it very well could have been that it was missed by Wayfarer, because they get the full package. They get all of everything unsealed initially. And then when it's unsealed for us, they probably don't go back through it all again. And it was such a big thing at the time, so it could have been very, very easy for that to have been missed somehow. But it looks like, oh, good. People on Reddit are looking for it too. No one has found them. Interesting. Yes, the text with Taylor did seem malicious. So much seemed malicious. But they didn't get a chance to collect discovery before their case was dismissed, and I'm still angry about that. But so if you have not seen the settlement, you can go to that docket updates and see it there. It's there's a lot more to it than what we originally saw. A hearing transcript. Okay. Is it from the last one? So Christina says Carol also added a hearing transcript today, and those are amazing, because the last few we were not allowed to listen in because they had them in person in the courthouse. And so we just had to rely on people's notes who actually attended. And so it's always nice to get to see the actual transcript, because then you get every single word. Because I know when you're sitting there taking notes, it's hard to catch absolutely everything. Oh, you are. Irma, you're amazing. So many amazing people in this community. I absolutely love you guys. Um, I am Irma says, Cassidy, I'm going to the court clerk next week on Monday to inquire about it. That's awesome. Yeah, because they were supposed to be unsealed, and we need to be able to see them. But Carol, if I get this wrong, please correct me. But was it that they were related to something that was supposed to be like proof of something malicious on Ryan's part? Did I get that wrong? Correct me if I did. I don't want to say something so important as that wrong. But if if that's true, then it's really, really important that those get unsealed and that we all get a chance to see them. But yeah, two Ryan messages. That's huge. Okay, so but yes, so back to the point. I know I've been interrupting and talking about new messages, so I haven't kept my message all together in one. Okay, it was Carol says, oops, sorry. Carol says it was related to Ryan's Rule 11 sanction, and that they proved malice, and they attached 9 exhibits, but we only got 7. Okay, so it sounds important. And I hope they get found, especially if there's something like a Ryan text message. So the hunt is on for that. And if you're not sure, I put a link that should go right to the timestamp of when she's talking about that specific thing. But I would recommend watching the entire video, because it's really good. But it was about this latest ask of Blake, and it was ruled on today. Like I said, I wrote this episode yesterday, but I wasn't able to go live about it last night. So I'll go through what she asked of the court, just in case you guys didn't see it already. I know probably most of you already saw it because it was released yesterday and or was filed yesterday, and I know everybody stays on top of that stuff. So, but I will go through it briefly today before I get to his ruling that you've might have already seen as well because it was released several hours ago. But here's what she asked. She hasn't changed one bit. I It's not like I thought she was gonna, but it needs to be said. So we're going to start off here. Blake Lively writes to request clarification and a short extension. So another extension. On the June 22nd, 2026 deadline, the court set yesterday for Ms. Lively to file her initial brief on the appropriate measure of fees under California Civil Code Section 47.1 as set forth in the court's order yesterday, June 15th, 2026. And I strongly look forward to a day when I don't hear 47.1 anymore. It's gotten to be so cringe. It almost makes me gag when I hear it. But she is insufferable. And it just it was he wasn't real. We're going to look at his order again. He wasn't real specific in it because he didn't he denied her damages, which would be the only like really new kind of thing to deal with that would need extra consideration. Attorney's fees are pretty much attorney's fees. So he probably didn't feel like he had to give a whole lot of information on that order. It was just, hey, these are the deadlines and submit them. Okay. And from that, we get this insufferable request for now. Oh, I'm gonna get ahead of myself. So let me not do that. But I want to point out, and Carol and DFJ mentioned this yesterday too when they went over it, is this initial brief because he simply asked for this stuff. It's very standard. Attorney's fees are so standard that he didn't ask for much, and now she comes in with initial brief, and that lets us know, uh-oh, she thinks that this is going to be ongoing. Like she doesn't want to let this lawsuit go. Every little piece of it she's gonna cling to and turn it into a mountain. So yeah, I got the same opinion as they did about that, say calling it an initial brief, because when you say initial, it means you think there's a bunch more coming. And I think it was DFJ said she hopes that he puts out something. No, don't need any more briefing at this time. We'll see if he granted her wish. But she's quoting from in that part that she just said right there, appropriate measure of fees. She's quoting from his footnote, and because she cites it there, you could see citing his docket. But here's what it is. It says the court makes no findings or holdings at this juncture with respect to the appropriate measure of fees for the subject of this motion. Lively's defense of the Wayfarer party's complaint in the Wayfarer action. The court may decide issues of liability for fees before receiving submissions on the value of services. The ultimate fee determination may depend in part on apportionment principles, including the extent to which fees were incurred, on issues common, that's an important word there, to claims for which attorney's fees are provided by statute and claims for which they are not. It simply means, the way I took it, the court is not yet deciding how much attorney's fees Lively can recover. That decision will come later. When the court does calculate fees, it may need to sort out which legal work was related to claims that allow fee recovery and which was related to claims that do not, and adjust the award accordingly. It's that simple. That's all this means. It sounds more like the court telling her that she can submit her invoices, but the court may decide that they don't all qualify, that not everything that she puts on there is going to qualify under fees. And it's instead of taking it like that, it seems like she's taken it to be, oh, this special and all powerful law that lets me do whatever I want to do and grants me the universe. It means I need all this extra time so that I can really sort through and sort this out. When I don't feel, I mean, I don't know about you guys, but when you read this footnote, it's very simple that you can. And it's not uncommon for someone to ask for attorney's fees and costs and get some of them shot down or get told you're asking for too much. It's a normal part of fees. One side submits, the other side argues, and the court decides it. And I feel like that's all he's saying here. But because he hinted about 47.1, they're like, oh, we got to make a brand new federal case about these attorneys' fees. And why do I say that? Because now we see her almost salivating as she wields 47.1. Again, like I said, like it's a magical sword or magic wand. And she starts talking about these legal principles under 47.1. But what's interesting to me is the law itself is quite simple. And it talks about, like, when you go through, I just went through the history of it when I was reviewing the order and listening to Victoria talk about it too. It was about, okay, so there was already 47 on the law books. It was already there, but she felt that there was something missing, that there were holes, that there was something that needed to be added to it. And therefore, we don't have a law with its own individual number. We have 47.1, almost like it's an addendum. I don't know that it's fully an addendum, but it was meant, and she herself said it. And if you look at the videos of when they were talking about it, and if you read through all of the information along the way of that bill becoming a law, that's what they said. This fills holes. So nothing in the law created a new method of calculating attorney's fees or costs. It doesn't say anything about that. Now, the damages are different, and so it clarified that. It said treble. And if you go through the history of the bill, it talks about, and if you listen to Victoria Burke, she says that these victims would get hit with a defamation suit. They've already struggled to get someone to represent them for their case. But then when they get hit with this defamation suit and it doesn't look like it's a high percentage chance of winning, or they simply don't have the money to fight a defamation lawsuit, because in civil court, you don't get public defenders. That's for criminal court. In civil court, you're on your own. And so what happens is it's really, really difficult to get an attorney willing to take on defending you in that defamation case. And so this law, as she explained it, not Ezra's whack interpretation, is that she said this incentivizes attorneys to take those cases. So it wasn't meant to completely rob someone of a chance to defend themselves. It was to incentivize. And she also said that it was meant to be something to make them think twice about a false defamation suit And she said something very important. She said, before it is filed. She never said before discovery, before in the motion to dismiss stage. That was something that Ezra and the Amici people said on their own. That is not in the law. And you heard Victoria, that was not what her intentions were. And so those damages, because that was a big part of the reason for the bill, was the incentive of these um, big damages, that it would incentivize the attorneys and then make the others think twice about a false defamation lawsuit. So the law, I'm still not fond of it as written. I think it still needs tweaked. I still have always held that I think a good solution would be, and I think before you go to civil court, like if you're assaulted, try to do it criminal first, and file for an investigation, and then have that, and you've got strong evidence that this happened to you, and then take it to civil. But and then that would weed out the false accusations. If it was required before 47.1 could be applied, if it was a requirement that you went to either the Civil Rights Department or the EEOC or a neutral law firm and you had it fully investigated, and then apply a law so harsh and difficult as this, I'm all for that. I'm all for that. But we don't live in a world where every allegation that's made in court is true. We saw that with Blake. And so I think standing alone as it is, it's it's scary. It's scary and a little unconstitutional. I still hold to that. But so here let's get back to the rest of this. So it says, specifically, we respectfully request that the court clarify whether it is seeking briefing on the legal principles. He just asked you for your attorney's fees and costs, for recovery of attorney's fees and costs under Section 47.1, including issues of apportionment, for example, or the extent to which fees were incurred on issues common to claims for which attorney's fees are provided by statute and claims for which they are not. Miss Lively's motion for attorney's fees and costs seeking a sum certain with supporting materials such as affidavits and billing records and corresponding opposition, or 3, any other subject. If the brief is primarily intended to focus on legal principles, Miss Lively respectfully requests an additional 7 days to June 29th, 2026 to submit her initial brief. So why does she need extra time? Is it because you took that footnote and his wording and you're like, oh, another chance to go wild with 47.1? Because that's what it seems like. That really is what it seems like. But and to convolute and be like, oh, let's make these, because let's talk about this. It's this is specifically the only aspect of her case that she gets to collect these attorney's fees on, is defending herself against the defamation claims. Now, if you remember back, that was decided in something like June 9th of last year. So well over a year that was decided. That means from that point on, there were no more filings about it, nothing. He had not allowed her 47.1 at the time. He denied it without prejudice. He gave her the opportunity to refile, and she did refile again. So that would be included. And then this stuff that we're going through now, I'm guessing would be included. He'll decide on that. But if you go back to when she wrote the motion to dismiss. That was back in March of last year. So she wrote it, Wayfarer responded, and then she got last word. She got to reply to their response. We are not talking about the entire life of this lawsuit. We are talking about those few documents that were related to defending herself against that defamation. It's probably less than 10 documents altogether, except for this new stuff now that they're dragging out. But here's the thing. I've worked in firms. Attorneys are meticulous about keeping track of their time. They all have set standards about what the cutoff is. If they take a phone call, not every phone call lasts 15 minutes. Some of them bill, if it's from 1 to 15 minutes, they bill 15 minutes. Or some of them have a little bit less time, like maybe 5 minutes, whatever. They are meticulous about the time because they're not handling usually just one single case at a time. Usually they've got multiple cases going in different stages. So they come to work, they don't sit there and spend 8 hours on the same case on the same day. I mean, sure, some days are like that, but other times they could work on, I don't know, 5 cases in the same day. And so in order to bill that correctly, they are just absolutely sticklers for writing down which how much time they spent on which case. And then they usually have their administrative staff take those, keep them totaled, keep them journaled, keep them documented, and then they use those for billing. And as there's an attorney I follow on X, and he made a comment about this, and he's like, "You better believe we are billing people like Blake. We are not giving them breaks." And I forget what else he said. But my point is, if she filed this motion to dismiss back in March, those fees were paid a long time ago. They may have come out of what she had already put down as a retainer, since it was that early on in the case. That might have already, like, that might have been used up by her retainer. But my point is, those hours are in a ledger somewhere, carefully, meticulously documented. It's not something that's hard to sit there. I mean, if you're sitting there now and trying to think back about how much time you spent on that case, you are doing this very wrong. That's crazy. You do it at the time so it doesn't get forgotten, so mistakes don't get made. And it should be as simple as a few keystrokes on your computer to find what the billing was on that. And like I said, it should already have been paid a long time ago. There should be receipts to that. It should be so easy. Not only that, this settlement was made last month. What day was it settled? I guess I didn't write it down. But was it May 18th or something like that? So they've had all this time. They've had almost a month to go through and get it all together. Why haven't they? Why do they need a whole month more? And the judge gave them a week. He knows how long it normally takes. So for her to ask for 30 more days is just incredible. It's absolutely incredible. Now, I do have to say that unless the opposing party can show a good reason why this prejudices them, I figured it was going to be granted. I was hoping that it would just be the first ask 7 extra days and not the 30 days, because that was just absolutely ridiculous. But I knew he was going to, and I can't really say much about that because Wayfarer didn't respond yet, and I think they would be hard pressed to try to present to the court a legitimate grounds of why that it would prejudice them to give her that extension. So it was gonna happen, and it's this one time, I don't think it's a big deal that it was. If he had given her 30 days, I would have been mad. A part of me was like, "What if he gives her till the end of this the Jones versus Abel?" You know, I didn't know what to expect, to be honest. But 7 days is not bad, and it's not against any kind of normal way of doing things or anything like that. So this time, I'm not gonna get mad about that. But, then her second ask is, let's see, where does it go? If alternatively, the court is seeking briefing both on the legal principles and Miss Lively's motion for attorneys' fees and costs, seeking a sum certain, with supporting invoices and other supporting evidence as to the reasonableness of fees and costs, which you should already have together, then Miss Lively seeks an extension to submit her initial brief until 30 days from June 15th, 2026, or until July 15th, 2026. This is absolutely crazy. And it did trigger when she asked about the extra time for the summary judgment response. Do you guys remember that? She already asked for way too much, and I was like, there's no way he's gonna grant that. That's crazy. And then he went and gave her like 2.5 months instead of what she asked for. So I was kind of like, yeesh, we just never know. We never know how it's gonna go, right? But I wanted to look back at what his order said. This is all it says. It says the court has issued an opinion and order regarding liability for attorney's fees and costs under California Civil Code Section 47.1. By June 22nd, 2026, Lively shall file papers regarding the appropriate measure of fees. The Wayfarer parties shall respond by June 29th, 2026. He doesn't say anything about needing extra briefing to deal with 47.1. He puts this in there just like any other request for attorney's fees and costs. Like no big deal. And so I think, I don't know, out of an abundance of caution, because it is a new um law, he doesn't wanna look bad, and you can't really blame him for it, and like I said, I don't think this is prejudicing Wayfair other than, like, they want this done and over with, and it's a nuisance, but, I think he just didn't want, when they brought up 47.1 as their typical kryptonite, I think he just didn't want to fight that. I mean, what judge wants to look like they're going against a Me Too law? They they don't. LA Girly, thank you so much. Hi, Cassidy. First time commenting in a live. Well, welcome. We have the sweetest, sweetest community here. And so you will fit in just fine with everybody else. Julia. I love you guys so much. I really do. For those of you who weren't here before the live started, I was telling the ones we were kind of chatting before I started, and I just got through. Somebody came with a big old fight about my hatred for Lyman, and I just and you guys know how I love being told what to do on my channel. I always try to respond and, like, explain myself, but this person was just getting hostile. They were so insulting and, rude and fighting with other people, and finally, I'm like, "You know what? You're getting muted." Because I felt like I'd given enough times of trying to explain myself, and the person wasn't even listening to my explanation. Or or they were saying, "Well, all the attorneys are fine with it and blah, 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 and you always criticize." And I was like, "Wait a minute. There have been plenty of attorneys both ones who regularly cover and outside who comment elsewhere, people that I know in real life that I talk to about this stuff that have said that have agreed with the things that I've said and that have found things about his decisions that they'll say. They don't go as far as I do, but they'll say, "Well, I wouldn't have ruled that way," or "I don't agree with this." I mean, not actually Golden did in this latest one. That order about it. She said there were things. And like I said, and not to the extent that I do. These people are attorneys. They're known and they don't want and they shouldn't come out and attack a federal judge the way that I do. They shouldn't, and they won't. Even if in their heart sometimes they feel the same way I do and you do. They're not gonna do it. And we shouldn't expect them to. And we shouldn't say, well, because they didn't, that it means that that questioning him is wrong. That's not what it means at all. So anyway, Cassidy side quest. But yes, I agree with that. I absolutely agree with that, Ashmeyer. It feels like Blake needs or is addicted to have her name in the headlines at this point. Why else is she going through all this hassle? And yeah, it's almost like how when you have kids, I relate it back to my teaching days when kids act out, sometimes they want attention and they'll take attention whether it's positive or negative. It's like that. It's like that. You guys are so supportive. Thank you, Donnie. Yes, me too. Me too. And that's what I was complaining about. That's what I was complaining about. I've and those of you who've seen the 2 videos I've done so far, I only got to page 5 so far. There's still a lot left to talk about, but what I complained about was this, that like Daphne says, I'm still ticked that he didn't let Justin Baldoni at least go through discovery. I talked about that. I talked about why I thought it was wrong. In the second one, I went through and I found that he had taken 2 quotations, and in between them, he submitted his own line as if it were part of those, and so I went to see where he got that line from, and I traced it to a questionnaire, like I said earlier, that was put out before any of the amendments took place, and it was one little bullet point in a questionnaire. It had nothing to do with that bill becoming a law, and it was never ever repeated again. And he put it in there and called it one of the most important bits about this law, and that is simply not true. And he used it as his reason for dismissing it, and I called it out. Hey, Lauren, are you still in Australia? She's looking for pie. Is she in the right place? Absolutely. I am going to make you a pie one of these days, Lauren. I need to know what your favorite type of pie is. Because I know for myself, I don't like cooked fruit. I like making pies, but I don't like cooked fruit. And I know, oh, you're only there for a week. Oh, that's not enough time. That's not enough time to go so far. But yeah, I remember you mentioned something about strawberries. I make a delish apple pie. I love making pies, and I love pumpkin pie. Oh my goodness, do I love pumpkin pie and key lime and lemon meringue. I love those. He is. I saw that Perez is moving to Florida, and now you guys have totally pumpkin and apple. Pumpkin is, oh my goodness, that is the best pie in my opinion. But yeah, Lauren, you'll have to let me know what your favorite is. Oh, pumpkin or apple, you already told me. All right, one of these days, you will receive. Okay. All right, I already covered that. Okay, here we go. So she continues on. I hope I completed whatever it was I was talking about because I got so You used to hate cooked fruit, but you love it now. It's a texture thing for me. It's a texture. Oh, macarons. Absolutely. Definitely. Lauren can go back to New York City and knock on Blake's door and ask for fried chicken, I mean cookies, and a nice glass of iced milk, watered down with ice cubes. Who does that? Who does that? I love my milk as creamy as it can be. Cassidy doesn't like lemon pie. I do not. I do not. Um, where did I saw something I wanted to say. Oh, hey Trish. Um, yes, texture with food. It's a neurodivergent thing. Is one of my biggest issues and why I cook at home a lot so I can make it how I want. Absolutely. I like cooking too. I don't do it near enough, but there was one I saw that I've yet to meet a pie I didn't like. I can't remember what it was. Oh, and the cream pies. Of course, the cream pies. Jungle Veg Jill. I wonder what kind of pie Ryan's forehead like. That extra mouth he's got on his forehead. It might have different tastes than him. It might speak differently than him. Maybe it's not as vile. Maybe he should let that speak from now on. Oh my goodness. Okay. So she continues with the nonsense. Under Federal Rule of Civil Procedure 6B1A, a court may extend a deadline for good cause, with or without motion or notice, if the court acts or if a request is made before the original time or its extension expires. And every time I have seen her say this, I've just wanted to slap them all because I will never forget that Brian Friedman's house was literally burning. LA was burning. And he asked for an extension, and Blake said no. Has there been a better cause in this whole case than that? Than my house is gone? I'm displaced? I lost everything? Has there been a better cause than that? And Blake said, no. And so every time I see her say this, I just get so mad. Courts have wide discretion in granting extensions to litigants. Good cause is a non-rigorous standard that has been construed broadly across procedural and statutory contexts. Extensions requested before the deadline should generally be granted absent bad faith or prejudice to another party. Now, bad faith, I feel like, is definitely a thing here. But like I said earlier, I don't think Wayfarer really could have come up with a good argument to say it prejudiced them in any way, other than they want to get on with their lives. But it still annoys the heck out of me that she wants to ask for this. Yeah, and she doesn't. She doesn't, Julianne. She says Carol pointed out they never showed a good cause. They don't. They really don't. Here's their attempt. Good cause exists to grant the requested extension here, whether it is a preliminary brief on legal principles or a more fulsome fee motion. The legal issues raised by Miss Lively's fee motion, including apportionment, if any, under civil. The way they throw this around, how many times did they say 47.1 in this teeny tiny little letter? How many times? And I feel like every time they do this, it's just to get it back in the news cycle. They love this law being out there. In the context of a consolidated action like this one, are novel in light of this new California statute and potentially complex and require adequate time to research and brief for the court. So they basically are like, okay, this new law 47.1, that's our good cause. They don't go in to explain what it is about this law that will make their presentation of attorney's fees different than in any other case. They should well know that by now. They should have this all lined up and ready by now. What why isn't it ready? An extension was properly granted where plaintiff filed a lengthy complaint and named over 70 persons as defendants. It's laughable to me that she puts this on here as supportive case law because this case had over 70 persons as defendants. That is a very, very different thing. That's not like hers at all. But that's the only authority that she cites and then says, well, this law, and that's it. That's it. That's her definition of proving good cause. In addition to the extent that the briefing contemplates submission of billing records and affidavits, it will require close review of complex billing records across the multiple firms representing Miss Lively in this matter, as well as the corresponding affidavits from lead counsel at each firm, which is not feasible to complete on the current schedule. Why aren't they finished? These would have been billed and paid for. How are they not finished? And that it's not feasible to just put them together when you settled a month ago. This is especially true given that Miss Lively and her attorneys, this part made me so mad, have a number of conflicting personal and professional obligations, including international travel. Okay, we know Blake's not working. These attorneys, they planned on, what did they say, like 6 weeks of trial starting May 18th? Why did they settle and then make international travel plans for this time period? And like I said, they would have, these records are history. They're way up there in the ledger at this point. They're paid at this point. They have receipts at this point. What are they even talking about? That it would be a problem for them. Why did Michael Gottlieb, as it says, one of Miss Lively's lead attorneys, Mr. Gottlieb, who will need to review and approve any billing submissions and sign any affidavit on behalf of the Wilkie firm, is currently out of the country? Why did he do that at this critical point? And he sure had time to send stuff off about Texas, didn't he? So what in the world? Thank you so much, Colleen. Exactly. Trying to cook those books. So Wayfarer has to reply, contest the amount. So this can go on and on. This is exactly it. Because at this point, the judge has now ruled that they do get attorney's fees and costs. They didn't know if they were going to get them or not. So now that they know the bill's going to be billed to Wayfarer and paid for by Wayfarer, they're like, okay, how can we draw this out and get more money? Right? I've that's the first thing that popped in my head too. Exactly, Frankies. They only pay their bills once they have a lien placed against them. And even then, that lien was placed in December. This is June. They only paid him because it got reported and spread and even made mainstream media. So that's why they paid it. If they really had concerns to pay it, they would have paid it off a long time ago. Okay, yeah, I read all of that. So yeah, so Wayfarer has to waste another week before they can get this all put behind them, which was a big reason of why they settled, because they just wanted to get it all put behind them and get on with their lives. But because Mr. Gottlieb is out of the country and there's some personal things going on between everybody. Ridiculous. Okay. But again, it's attorney's fees and costs, and nothing in this law, no matter how new it is, said that there's anything different about attorney's fees and costs. Absolutely nothing. And so why would you need 30 days for standard attorney's fees? Research what? Brief the court about what? So it says, sorry. This part made me literally laugh. Miss Lively has not acted in bad faith, and a short extension will not prejudice defendants, who will be provided adequate time to oppose Miss Lively's motions. So they cite this case, good cause for extension existed where non-moving party failed to show or even argue that he was prejudiced as a result of the 20-day extension. And Wayfarer is like, we're not even going to comment. We know what you're going to do. We know it's denied in part, granted in part. Why bother? Why waste our time? Ellen didn't even see fit to send it from her iPhone. They're like, whatever. We know what the answer is going to be. Miss Lively has timely sought an extension 5 days before the original deadline of June 22nd. Good cause existed where movement sought an extension 5 days before the deadline, quoting again from that case. Thus, Miss Lively has demonstrated good cause. Hold on just 1 second. And easily satisfies the non-rigorous Second Circuit standard. I am Irma. This made me giggle. I wonder if Cassidy uses heavy paper. I asked because I can always hear her turning the pages. They sound heavy. Yeah, because my printer, I love my printer. If anybody is in the market for a printer, EcoTank is amazing because I print so much. And if you just use the standard cartridges, if you don't use it enough, they can end up drying out too fast. And if you use it too much, you have to keep replacing them so often. So these are the ones that you like pour the ink in and it stores it and it lasts so long. But one of the things about it is and this is very common with lots of printers, if you use too thin of paper, it won't read correctly and it keeps thinking there's a paper jam or that you're out of paper. And I overreact to my printer not printing. So at this point in life, I have made it my life's goal to just rule out anything that is not only not bringing me joy, but making things difficult. If it's something small like that, that I can easily handle, that's what I do. So yeah, Cassidy side quest. That's the details about my paper and my printer. And now this part's funny too. Miss Lively met and conferred in advance of this request with the Wayfarer parties who objected to any effort, of course they did, to seek clarification or extend any deadlines, including the response deadline. So they're like, we don't need our deadline extended, and neither should you. And no, we're not doing this. Oh, did you? I am Irma. Found an EcoTank printer in my apartment building's courtyard. I still use it. They're amazing, right? I had one of their earlier models, and then I upgraded last year, like the end of the year last year. Sorry, I'm trying to get this. Because the one I had it for years. It did really well, but it didn't print all the way to the edge, like if you're printing a photo. So there was always like a little white border around it. But even that, like that wasn't the only thing. But the newer ones, they take the paper suck it back in and print on the other side. Where before I would have to print all out on one side, then turn it over and have it print on the other side. And if anything went wrong, then the pages were not matched up right. And at the time, I was printing some really, really long stuff and printing lots and lots of stuff. So I really didn't want to have to keep doing that and then having it messed up. And so that's why I upgraded, but my old one was still printing. Okay. And so this is what he ruled today. He said the request for an extension is denied in part and granted in part. Each part each party has leave to file a memorandum of law. And this is where I love this. He's like, okay, fine. I'm not going to deny this because then it might come back at me later. So I'm going to grant it, but I'm going to, like last time, put a leash on you because I know you get out of hand. No more than 10 double-spaced pages. And remember before they've done all their dirty little tricks of like way too many footnotes or putting not counting some of the pages like the signature page and stuff. And thank you, Colleen. Thank you so much. Earlier, I meant to ask this as a super chat. If Blake was actually working on 47.1 with her lawyers, isn't that some sort of conflict of interest? Thank you for everything you do. I love your channel. I will tell you honestly, I don't think so, but I am not 100% certain on that. I do know that many of the people who are working together to help get Victoria's law passed. In fact, I was surprised when Victoria came out. I thought, is this woman claiming this? Because I never saw her name on anything. I did see it mentioned when I just went through the history of it, but I saw a lot of other names that came up like higher than hers. So a lot of people worked on it. A lot of them were victims. Women that really wanted it through for their own cases, just kind of like Blake. And they actually came and spoke before the Senate, before the Assembly, about their experiences and why they wanted it. And I think at least one of them did have a case still pending. So I am not 100% certain that answer is correct. But I don't think that it's a conflict of interest if she were. I think it's very, very questionable that Ezra was doing this and that she was attached to at least one of the amici that filed an amicus brief in this case. That was questionable. And I would wonder what she's doing because Victoria said she's trying to get some kind of special provision in there for attorneys. And she's like, that's not what my law was for. My law was for victims. And it already has that possibility to incentivize attorneys by giving them higher earning potential and an easier path toward winning the defamation suit by upgrading the standard to actual malice. So yeah, but I'm not saying that with confidence that it's 100% correct. So sorry, I would have to look into that, or and that's a complex part of law. Yeah, I don't know for sure. I'm sorry. Sorry, I don't have an answer. But thank you so very much for that. Okay. So in addition to limiting their, and he says double spaced, he's like, not 10 single spaced, 10 double spaced pages, excluding a table of contents and table of authorities. He gets more descriptive each time. Laying out the legal principles that they believe the court should consider. Lively shall file her, and shall is like must, file her memorandum of law with declarations and proof sufficient to support her application for attorney's fees and costs no later than June 29th. So he just gave her an extra week. And even though they said, well, Wayfarer didn't, they declined Well, how did she say it exactly? Objected to any effort to seek clarification or extend any deadlines, including their response deadline. I feel like she put that in there to say extend mine, but Wayfarer said no, so don't give them one. And I love that he did. He I feel like he kept this one fair. That he gave her the minimum of the 2 that she requested, and he granted the same to them, to Wayfair. He gave them, instead of 1 week is what he initially gave them, but this time he gave them 2 weeks. Because there have been times where he gave her much more than he gave Wayfair. So, I have to say these things here, I'm not, or this one order that he's done, I'm not upset about. So, we need to write this date down in history. It's a very important day. It's I'm not mad by an order issued in this court in this case. Amazing. Then he says, after he gives the Wayfarer's date of July 30th, he says, the court will not accept additional briefing or evidence absent good cause shown. So DFJ kind of got her way. She had requested, she's like, I hope he puts in there no additional, the court does not need any additional briefing. But this time he goes, will not accept. He doesn't say, oh, I don't need it. He's like, I will not accept it. So I hope he keeps this attitude with them. I think he just wants this case wrapped up at this point. I hope that he's finally had it with all of this nonsense. So, yeah, that is that. But I also Ezra will send it anyways. Oh, I fully expect her to ask for more on her 10 double-spaced page. Now, I wanted to talk about this. I'm not gonna go through and read every word, but I felt like this was worth mentioning because The Hollywood Reporter has been absolutely awful. So skewed towards Blake. The way they presented the settlement was one of the things that made me maddest on X, was how they blatantly misrepresented her win, they called it. And it had all of the Blakeys underneath it and coming at me and coming at other people that I saw, like Jesse and other ones who try to put the truth out there. And so I was happy to see this one, just to point out to you that maybe the tables are turning as people are starting to actually read these or read the community notes that are being put on things. And I always know that that's a possibility. I'm trying to be positive. The one you don't know says, Cassidy, he's just acting, don't believe. Um, it's Lair, like a trap? Slimy Lyman, he will accept anything Blake asks. I'm going to be happy this one day about it, and knowing fully well that it won't last long. So they actually say that Blake Lively made a bold wager on a legal theory and lost. I'm still not promoting this tabloid because most of the time their stuff is absolutely awful. But I just wanted to bring to your attention some of the stuff that they said that was kind of funny. The aftermath of Blake Lively's 11th hour deal to avert a headline splashing trial. And I thought that was funny, like that they said it. They have been so supportive of Blake that this just absolutely shocked me. Yes, Kitten Kiddo, Hollywood Reporter is their mouthpiece, like people who believes these rags. It has been terrible, to the point I feel like Leslie wrote the articles herself, or Ryan. And so I couldn't believe that somebody said it like this, that she wanted to avert a headline splashing trial. That is very much not in her favor. And I mean, I don't read them regularly, I don't pay attention, but anytime I see them posted on X, it's always a serious misrepresentation of what happened. They mentioned how Baldoni's lawyers played up the absence of any monetary payout to Lively when they had been making it like she just won and was getting all of her damages and fees paid. So it's a really quick turn of events. Um, Lively's lawyers celebrated an acknowledgement from Baldoni that the actress claims deserve to be heard. They also made a bold wager that Lively would soon see damages and the recovery of her legal costs by way of California law. That was something that they said. And let's see, what else did I? The gambit ended with a whimper. That was another thing I appreciated because it does not sound good for Blake. The court ordered Baldoni to pay Lively's legal fees, but rejected her bid for damages, and that ends her last chance at a payout in the case. Because the day before, it was being said that she could take this to another court and find other ways to still get her damages. And then when the settlement was released, it was like, no, that's not possible. And Brian Friedman also said, no. And I like that they said that they quoted Brian saying all Blake Lively needed to do was to say, no, I'm not settling. Let's go to trial. And that kind of shuts people up. That's kind of one of the things I saw other people who are trying to get the truth out there say, that if she had these mountains of evidence that she told us all she had, she didn't have to settle for $0. She could have gone to trial and shown those mountains of evidence. And if they were so good, she would have won. And like he continues, if it was so good, why do you settle a case exchanging no money? It makes no sense. And he also downplayed what she got as procedural, pretty standard. But when you want to parade around and call a loss a victory, this is your attempt to do so. I really love that stuff. And then it quoted some good stuff from because there is some good stuff in the order. I haven't gotten to that part yet, but I said in my first video about his order that I did love that he did take some time to call these folks out. When they said, "Oh, the court's already ruled," he's like, no, I didn't." And he also said, this does not create an end run around the entire set of carefully crafted federal procedural rules designed to protect the rights of the parties. And this was good because he was acknowledging, and I was happy to see it, that Wayfarer did have a right to defend themselves. And instead, it establishes a narrow exception to the usual litigation, and then ruled that compensatory and punitive damages do not fall within that exception. Let me see what else. And then also Friedman's response to the stuff that Michael said. And Friedman said he didn't get the result that they hoped to get in this case. When you bring a case and you hope to prevail on that case, if you have the evidence to show that you're right, you go to trial. And so it was really easy for us to end up in trial. But anyway, I love to see any tide turn that brings out the real side. What am I missing about Victoria? Of Blake Lively. I heard something about this and I didn't get a chance to get to the bottom of that. Jungle Vet Jill says Victoria was working with them before the lawsuit. They dropped the New York Times article trap the day after it passed, and Vicky admits she was sneaky. So how did they know? That's an excellent question. That's an excellent question. And like I said, I still have issues with this law. Um, I my feelings were softened a little bit by hearing her, but I also feel like it was all fine for her until she got excluded. And yeah, I don't know. Yep, it really is. And now she knows how Justin feels. Mazdod says this is just the attempted legal takeover of a new law in the same vein as the BLRR attempted takeover of Wayfarer's movie and possible franchise. Yep, it definitely is. It absolutely is. And then Michael has to say that the reaction to Blake bringing this lawsuit at first was positive. That began to shift after the Wayfair parties filed the defamation lawsuit, went on a press tour branding her a liar. No, sir. It was after we started reading stuff and seeing evidence. It was not a press tour. It was a website that contained public filings and a video from the movie. That's all. And then from there, we started reading between the lines. That's what happened. Not, there was no press tour. And then they say the last remaining issue. Oh, JTOR, have a good night. Before the court is how much Baldoni should pay in legal fees. Nothing, but then they make this, they say this, nothing is stopping Lively from pursuing another lawsuit for damages over his allegedly retaliatory defamation claim. And I think this is why they ended up releasing the entire settlement. I think because of all of these rumors that were out there. And that was my thing. It's like they did all this to clear the reputation, and it wasn't cleared. People were saying all this crazy stuff. And so I think that was probably the motive. I could be wrong. But I think that was probably the motive in deciding to release the entire settlement. Okay. Next, I was told about an article on Reddit. And you guys know I don't have the best relationship with Reddit. And some of the people on there tried to find me in real life from this sub actually, and also think I should be in jail. So I mean, I have good reason to not, but when I heard this, I was like, okay, that sounds too good to pass up. So I don't know how many of you um no, Pam, that's the thing. That's the thing. I had said the other day, because we hadn't seen the settlement yet, and the way the judge had worded his order, it sounded like the only thing that was preserved was 47 point, or not preserved. The only thing that was not appealable, that they had agreed not to appeal, was 47.1, but that's not true. It's all of it, including Van Zandt. And Jennifer Abel signed it too. And I get, like, that's why I couldn't even talk about that settlement today, or yesterday, because I mean, I had real life family things, and then I saw that, and I was like, nope, can't do this. Too frustrated, and when I get mad, I cry, because Jen Abel signed it, and she still has her case pending. The Jones versus Abel case, and you know exactly what they're going to say. They're going to say, you signed a document signing away any further action on Van Zandt. And so Van Zandt, when they settled, they didn't just kill the chance to do away with 47.1, but they killed the chance to do anything about Van Zandt, and that's very upsetting to me. She didn't settle. Jen Abel signed this settlement agreement, but she didn't settle with Stephanie Jones. That's still ongoing. So she can still fight Stephanie Jones, but she can't fight Van Zandt. So all of our hopes for Van Zandt being dealt with in the Jones versus Abel case were killed by this settlement, and I don't understand that. I really, really need to hear from somebody from Wayfarer to explain why they let that go. Because this is what I started off saying in the beginning when I was saying that, like, when I dealt with my subpoena, I did it on behalf of everybody, and I mentioned it in my filings to the court, and he told me that I can't speak for anybody else. But no, Nikki, she was behind getting the contents of the phone. That part, Jen Abel can still pursue against Stephanie, but Blake filed the, Van Zandt. It was filed Van Zandt, and then Ryan stepped forward and said, "I am the CEO or owner of this company," and, yeah, but, I mean, I want to it is a separate case, but the settlement agreement touches on that. When I do cover the settlement agreement, I will talk about that, but, I also wanna see what some of the other attorneys have to say about it, specifically, because it looks like they signed away any future action in any way related to Van Zandt, Blake, or Ryan. And so Stephanie didn't file Van Zandt, Blake and Ryan did. So, yeah, but by settling this, I don't think, now don't quote me on this because I could be wrong, but my initial read through of it is that what it means. I hope that I'm wrong. Please, if somebody else says differently, let me know. I hope I'm wrong. I wanna be wrong. But, yeah, I, yeah. I hope it wasn't a matter of Jen Abel wanted to keep it, but she felt like she had to go along with this. I mean, I really wanted to see her come strong and loud against Van Zandt and get that ruled on in court in New York so that nobody could ever do that again. Yeah, I'll go through the settlement with you guys, but, I wanna hear, normally, I put my stuff out there before I listen to anybody because I don't wanna be influenced, but this time, there was a lot of the wording that I wasn't real familiar with, um, that I feel confident to give my opinion on it, if you know what I mean? So I was kinda waiting and hoping that somebody would break it down very, very thoroughly, and I could get a little information, but yeah, put it out there, ask. Yeah, third-party cases are excluded. However, Van Zandt is specifically mentioned. So I hope I'm wrong. Yeah, the Wallace case and the Stephanie Jones versus Abel case, not affected. But Van Zandt, she signed off on, and it wasn't mentioned as excluded. Daphne, you're getting ads for printers. Yeah, our phones are always listening, it's creepy. Yeah, you know what? I might go put a question actually in their comments and ask them to talk about that specifically. The Wallace case and the Abel Jones versus Abel case are excluded, in fact, but Van Zandt as evidence in those cases would be excluded, in my opinion. I hope I'm wrong. Please run to me to tell me I'm wrong if I'm wrong. No, the Jones case was not settled and it was not mentioned. But the Jones case Van Zandt is a piece of discovery from the case. It is not a party to the case. Yeah. Me too. Me too. I kept saying so, Moon Skittle says, "I was hoping they would pursue the Van Zandt sham. That would have proved malice." I was too. I was really, really hoping, and I was wishing that it had been resolved first before instead of the opposite way. Um, and that all of the Van Zandt sham could be discovered, and then it would all be there, court record, and then Blake's case could proceed and it could be dealt with. But it went opposite. It went Blake first, and then she settled and got them to sign. Yeah, I hope I'm wrong too. I really, really hope I'm wrong. I'm gonna go back and find the exact page that said that and show you guys in a minute. But this was too good to pass up because when you'll see in a minute, if you haven't already seen it, if you are not Redditors. So this is from the the Reddit account. It ends with lawsuits. I think this is the main one that talks about this case. Um, the one I really, really liked that I used to go look at before, and I don't think they said I was going to jail, and there was nobody on that one trying to find me because they modded it really, really well. So I will still go into that one a lot. Is Team Justin Baldoni. They don't let this one here. The reason it happened that a lot of us content creators got harassed in this one is because they considered themselves neutral. I think it's predominantly Wayfarer people, but they do allow Blake supporters in there. And so that's why there was some ugly stuff happening. But the Team Justin Baldoni, why I preferred that one is it was exclusively for Team Baldoni and they don't mess around. When somebody comes in there being nasty, they're gone. They're banned, done. But this one I was given the link to here. So it's Blake Lively's lawsuit may have been used by the Lively parties to hide an even bigger scandal, drinking at Betty. So this one's a little more lighthearted than what we were talking about. Look at this picture. I don't know if somebody created this from the description or if this is the one. If this is actually what she created. So I want to shout out the person who posted this. It is 77 Dark Horse 7. So after some questioning, an anonymous wait, what? Carol, they kicked me out of Team Baldoni because when I was first starting using Reddit, I liked to post about Blake Lively and I didn't even know. Anyways, they reinstated me after. Oh, good. I'm glad they didn't keep you out blocked on there. Yeah, they don't mess around. They are so I love it. Kenny, you got banned? Why did you get banned? Did you I love Kenny on X. Sometimes it's just like I just go there just to see it. It lets me get like my mental screams out when I'm so upset. I was too spicy about someone giving me a hard time. I could see that. I could see that. But right, Carol? It was so funny. I was like, "No, I'm the biggest JB supporter." Exactly. Exactly. So, I'm sure they know now. I think they promote, your website over there. But anyway, so this was juicy. An anonymous source has relayed information to me that oh, I already read that one. No, I didn't. That suggests that a huge scandal was brewing behind the scenes of the movie and the lawsuit that very few people knew was happening. This is the first I've ever heard of this. And it's an anonymous source. I don't normally talk about things that are not confirmed, but this person is very upfront that it is an anonymous source. And what I'm hoping is that somebody can investigate um, this bit and that the story will get bigger because it's so funny. The story goes like, well, not funny, it's a little bit sickening, but also a little bit funny. The story goes like this, and remember, it's anonymous, so this is allegedly at the moment, and stresses again, allegedly. In early 2023, numerous public reports from concerned outfits and authorities were sounding the alarm about alcoholic beverages and their non alcoholic crossover brands, that underage children were mistaking their favorite non alcoholic mocktails with their parents' alcoholic beverages because the branding was so similar. And I had never even thought about that. That is so true. If you keep them labeled the same and they're both sitting there in the fridge, the kids could grab the wrong one, or the parents could even give the kids the wrong one. So I can see companies or organizations going, this has to change. You can't do this. According to the source, Betty B Holdings, who in 2023 were just getting ready to launch Blake's new Betty Boo's alcoholic cocktails, had access to these reports, including one from something called the Distilled Spirits Council of the United States that outlined recommendations to counter this risk. They did a cost benefit analysis and concluded that since their cans were already made, they were going to gradually pivot their Betty Buzz brand towards glass bottles so as to make their cans less conspicuously similar to the Betty Boo's cans. But they would that they would refuse to change their classic Chaos Mountain Plane Ride logo. Okay. So this is going around. Most companies are like, okay, we'd like to comply with that and not contribute to a child mistakenly being given alcohol. And so they came up with, okay, we've already done these cans. It's going to be very expensive to change those at this point. We'll eventually move over to bottles after we deal with these cans. Betty B Holdings supposedly liked the idea. Betty B Holdings is Blake now. That the 16-year-old drinking their favorite Betty Buzz mocktail one year would grow up and find comfort in their favorite drink logo on a Betty Boo's can in a future year after he or she had turned 21. A risky prospect given the climate, but nevertheless. So here we have once more Blake taking authorship and going, okay, I know you wrote it this way and this is what you guys want to do. And you're the actual owners of the beverage company, and I own a teeny tiny percentage. But this is what I think, and this is what I want to do. Look at that. Yeah, it's crazy. It's crazy. This is Blake authorship, as it always turns out. Okay, anyways, that's where the chess pieces would likely have stayed. But authorship Blake had other plans. Allegedly, her marketing strategy was a nightmare and conflicted with the company's in house marketing plan. In addition to Blake's disastrous Kategate comments linked to the newly profitable beverage company, because remember when she made fun of Kate, um, Princess. Oh, why can't I think of her full name? Oh, good grief. The future queen, married to Will. But she had cancer. Nobody knew it quite yet, but she hadn't been around, and they posted a picture and people thought it looks like it had been photoshopped. And so Blake did one, and Middleton, thank you, to make fun of her. And it was a promotion of her beverage company. So it was disastrous that they were linked. So they were already like, oh, yikes. Why would you do this? Um, So they've already got that going on, and now they got the rest of this happening too. So Blake also released her own cookbook of Betty Boo's cocktails, featuring a 15-year-old redhead girl on the cover, ostensibly named Betty, wearing a golden bee on a chain around her neck. Again, allegedly. So, like I said, I don't know if this is the actual cover of that or if this is somebody's rendering of it, but this gives you the idea. You see the bee, you see an underage girl drinking this cocktail, and Blake thinks this is a good idea. But heaven forbid a 23-year-old actress who signed up to do a sexy movie does sex scenes in the movie. Okay, here, where do we go? It didn't end there. Betty B. Holdings was happy initially when Blake's acting career began to take off again because they wanted something to keep her busy and keep her fingers out of the marketing. But Blake decided to thrust her two hobbies together. Oh no, you're going to get subpoenaed by Blake. You said thrust. And market Betty Boo's during the movie. Betty B. Holdings, and by that I mean the shareholders and corporate officers, were horrified. Blake was promoting an alcohol brand alongside a movie about DV, but that wasn't their greatest fear. By some miracle, it didn't come true, but Since It Ends With Us wasn't only about adult domestic violence, the other half of the movie story was an underage romance. For the fear that Blake would somehow link those two things in everyone's mind was palpable. We know that she used to hawk Ryan's aviation gin in her movies. Remember, she forced Paul Fig, however you say his name, to put Ryan's aviation gin in there. Has forced people to drink them during interviews. And so they were scared she was going to do that again. Okay. Betty B. Holdings is, after all, an alcoholic beverage company named after Blake Lively's underage daughter. It might as well be called Underage Daughter Booze. This person is hilarious. So they were already way out on a limb there. Between the underage scandal, Blake's tanking popularity, and their cost-benefit analysis coming back at them, the crisis allegedly fell at Blake's feet in August of 2024. BBH gave Blake notice they were going to shutter Betty Boo's completely and give away their stock of consumable goods. They weren't even interested in recouping their losses on Buzz. They were fed up and were going to buy her out and move on with just the booze, sans Lively. We saw in the Great Unsealing that they had talked about closing it up. It was not profitable, and then it didn't mention all of this stuff, though. That's allegedly when Blake hatched her plan. To attempt to weather the storm, she proposed to BBH a plan to hide this scandal inside the lawsuit she had already planned to file. That's interesting. And make the transition last long enough to sell off the remaining costly goods at near market prices. Her ultimate goal being to convince BBH to abandon the shutdown altogether. She just needed time. She allegedly hid the chaos that was going on in her business by blaming it on the smear campaign story she concocted to frame Justin, and drew out the lawsuit as long as she could. I have been saying for a while, and I think a lot of you have too, that a lot of this is hand in hand. Her booze business was failing. She needed to blame that on somebody else, to victimize herself. And just like her reputation was tanking, and she needed to be able to blame that on somebody and get pity for herself. And this all just, she tried to roll it all into one. I'm sure under Ryan's direction. It didn't work. The backlash that was caused when Justin pulled out his receipts and cratered Blake's image thoroughly destroyed any hope of Betty Buzz having a future at BBH. BBH announced the winding down of Buzz in the middle of 2025. She was the one thing that could force the closure of a $3 million profit year brand. So, in her marketing of Betty Boo's are all the fruity and the candied colors and the picnic scenery with the cutesy girl wide-eyed bushy-tailed photos of Blake just to sell booze to responsible adults? Or allegedly, is something more nefarious going on? You be the judge. Allegedly. Isn't that a good article? I couldn't resist this one. I mean, I know, and this person, oh, I forgot this was in here. This person stresses throughout the whole article that it's all alleged, but it sounds very true. And it does line up with some of the stuff that we saw in the unsealing. It does mention the name of the company that did the that was bringing up information about the worries about labeling, having the kids look the same as the adults. So this is funny. I was gonna put this. I got a notice from X that my X account is having its 8-year anniversary, and I thought I'm gonna put this as my. And it said do a post to celebrate it, and I was like, I'm gonna put this as my 8-year celebration. So what this is? Do you guys remember? Um, I don't know, they started some time ago, these little apps that you could age yourself up, or you could, age yourself down, or you could put your and your partner's faces together and sort out, like, what it would look like, if you have a kid. Do you guys remember those? So I put her, like, pre-surgery picture through and aged it up, like, what would she look like today? 'Cause I always use, like, her younger versions, to, like, have her real face, but it's her when she was so young. I'm like, that doesn't quite grab it all like it should. So I'm like, what would she look like today if she didn't have surgeries? So this one already had her teeth fixed, but I don't think she'd had any no surgeries at all, or her eye surgery, or her lips filled in. So this would be this would be what she would look like if she never got surgery. And I think that's just, I don't know, just a fun thing. She looks like Rocky's manager. Anyway, feel free, it's Carol says, "Is that one of the Home Alone robbers?" It is giving that, isn't it? But just so you guys know, as with all of my thumbnails, you are more than welcome to use these when you post about the case. Um, Absolutely. So, yeah, take it, spread it, post it, whatever you want to do. Print it out, put it on the wall, whatever you want to do with it. Yeah, I forgot, and I should have. I meant to go back and look. I got this from somebody on X. I think it's Joyfully Observed. I think I'm also gonna post this on X. So if you guys use X, you can get a good screenshot of it from there. If or you screenshot it here is as well. But yeah, take it. It's I'm always happy to share my thumbnails and screenshots of stuff. So thank you so much, CM. I still call you CM baby. Okay. And she is a thief of valor. Okay. Yeah, and that's it. Kept it under 2 hours. That's amazing. Thank you so much for those gifted memberships. And there were Ricardo and LA Girly Colleen, Colleen again, and CM Baby. Thank you so very much for being so generous, and thank all of you for your wonderful support. I mean, honestly, like I said, health issues in the family that are very, very difficult. And, and yeah, I don't want to get too far into that. And then, like I said, somebody just coming on my YouTube channel and just being utterly nasty to me and to other people and being absolutely unreasonable, argumentative, insulting, and yeah. And on top of when you're already like that, and then the settlement, and when I read the Van Zandt bit about it, oh, that's what I was gonna look up for you guys to see if I can find exactly where it says that. Let me see if I still have that open to that page. Oh, shoot, I don't. What I was talking about, and I'll cover it eventually when I go over the settlement thing. I wanna get through the order first. I'm just so slow, and then I lost a couple of days. I wasn't home. Um, I was dealing with other things, and so let me see. Okay, that's page 9. Let me find Van Zandt on here again so I get the right. Okay, page 5 and page 9. Okay, let me pull this up. It about broke my heart, and again, um yeah, it was very depressing, Julianne, and all of that combined was not feeling it. And you guys, as always, you lift me up. You really, really do. I don't just say that. That is the absolute and complete truth. Oh, you guys are so sweet. Okay, so it's page. Oh, let me close this. Page 5. Can I highlight on here? I don't think I can. Because I opened it on here. Wayfarer parties release of claims. So, except as reserved above in paragraphs 1B and C, and that's the 47.1. It's not. I was hoping it's like, oh, did they preserve Van Zandt? No, those are 47.1. In exchange for the promises and covenants herein, the Wayfarer parties and their heirs, executors, representatives, administrators, agents, assigns, parents, subsidiaries, affiliates, predecessors, successors, and assigns. I'm surprised it doesn't say pets. And each of its and their respective agents, officers, directors, members, employees, attorneys, or insurers in their corporate and individual capacities, including without limitation, RWA Communications. I think isn't that Jen Abel's new agency? Um, Irrevocably and unconditionally, fully and forever waive, release, and discharge Lively and her heirs, executives, subsidiaries, all that stuff I just read. And then we get down to including without limitation Reynolds, Van Zandt, Family Hive, LOL Hada, Betty B, all of those. Let me get past that long list. From any and all demands, actions. So the action that includes Jones versus Abel, I think. Hope I'm wrong. Judgments, rights, fees, damages, debts, obligations, liabilities, expenses inclusive of attorney's fees, causes of action, and claims for relief of whatever kind or nature under any theory, whether legal, equitable, or other, under the law, either common, constitutional, statutory, administrative, regulatory, or other of any jurisdiction, foreign or domestic, whether such claims are known or unknown, suspected or unsuspected, that the Wayfarer releasers may have or have ever had against the released Lively parties, or any of them arising out of or in any way related to Lively's employment, the film, or the consolidated action from the beginning of time up to and including the date of execution of this agreement. It is expressly understood by the Wayfarer parties that all such claims, including related attorney's fees and costs, are forever barred by this argument, or so sorry, by this agreement without regard to whether those claims are based on any alleged breach of a duty arising in contract or tort, any alleged unlawful act. Look at this. I mean, and then it goes on to the waiver of known and unknown claims. So unless I missed a part where it's excluded, and please if you, because my brain has been scattered. I've had several days of medical emergencies and stuff, so I may have missed it. And then we go down to, okay, so the third party exclusion, this is what somebody mentioned. So yeah, so this means that Stephanie Jones can, or I'm sorry, that the Jones versus Abel case can still go forward. It doesn't take that away, but it takes Van Zandt out of it. Now I don't know if, as long as, I don't know if maybe that, I just thought of this, maybe they can still use that evidence, but they can't take any action against Van Zandt or Ryan or Blake for their parts in it. Now, if she pursues something criminally, this is all just civil stuff. That would be fun if she could still pursue it criminally. But I don't know if that counts. So yeah, I really would love to hear, like, not actually Golden or Little Girl Attorney or Omar or who's the guy, Ron Zambrano, to fully explain this, because I do not feel qualified to completely confidently say that that's what it states. Anyway, and then let's see, who have we got? Yeah, here it is, Jennifer Abel. So, I mean, there's a chance it could be that she can still use the discovery. She just can't bring any actions against them. That would help a little bit, but I wanted action to be taken against them. Maybe they couldn't prove. I mean, it could be that they couldn't prove that Blake and Ryan had access to it before. I don't know. and so they were willing to just let it go. But yeah, so Van Zandt will not be held liable for anything, and Blake and Ryan neither. So that is sad. But anyway, you guys cheered me up anyway. And I mean, criminal is not these people coming after Blake. It would be like a DA, or if it's federal, it would be them coming after, not these people. So yeah. Oh, is that true? Okay. An attorney said they could not file a sanction against it because no judge was assigned. So it could have been that that in the end, when they found it all, that yeah, it totally sucked, but they didn't feel like they had enough to prove what they wanted to prove, and so they just let it go. That could be. Yeah, definitely that part is true. They can't bring it into federal court. It was a state level. I remember Omar talking about they could talk about that the discovery came from that. But once you settle the case, you can't fight about what the discovery is. They could have only used that if they had continued on to have the trial, and then they could have filed motions in limine to say, hey, this evidence is not good. So, but when they settled, that there was no need for that anymore. So, yeah, I hope that Brian or Kevin or Ellen or somebody comes out and explains this part of the settlement, why they were willing to let Van Zandt go. I hope they do. But so as it stands now, I was heartbroken, but I don't know the legalities involved in it. So all I can do is be sad about it. Anyway, thank you guys so much. Thank you, Christina, as always. And yeah, we don't need to carry this. And it sounds like from everything that Brian Friedman has said that there is not a non-disclosure agreement, and so that they are going to get their story out there. I just hope that they're able to find a streaming service that will show it, because I noticed someone had commented, I don't know, was it Michelle, that Andy's having trouble finding a streaming service that will put his um documentary out there. So it could end up happening that Wayfarer makes an incredible documentary, but nobody will host it. So we'll see. I mean, if it's something that Ryan or people that support Ryan still have some sort of hold that would prevent it, I don't know. But it would be a moneymaker. It would be stupid for somebody to give it up when Ryan and Blake are, in my opinion, not ever going to be moneymakers again. But it's oh, I passed 2 hours now. Dang it. I talked too long. Anyway, all right. Thank you guys so much. Love you guys. See you soon.